Good morning, everyone, and welcome to the 2024 Cal OSHA webinar series. This is our last webinar of 2024, and it is our annual Cal OSHA Enforcement and Regulatory Update, getting ready for 2025. We are starting to put together our webinar series for 2025, so we will release that in the next month or so. If you have interest in being a part of that and being registered, please send any of us an email. We're happy to get you registered. And if you have any topics that you really would like to see us cover in 2025, we are happy to take suggestions as well. So please let us know. My name is Rachel Conn. I'm a partner here at Conn Maciel Carey. I am also chair of the California practice based in the San Francisco office, and my practice focuses primarily on OSHA compliance, litigation, audits, investigations, enforcement, rulemaking, everything Cal OSHA and really OSHA related. Prior to CMC, I was at Nixon Peabody, where I was the head of their OSHA practice group. I'm joined today by my partner, Megan Stevens-Shaked, who is also a partner here in the San Francisco office, and she focuses both on workplace safety and employment challenges for employers, and so that includes everything Cal OSHA representing employers in inspections, investigations, and enforcement, as well as defending employers in employment litigation and administrative actions here in California. We also have Andrea Chavez, who's our senior counsel in our LA office, and like Megan, focuses on everything Cal OSHA, labor law, California employment, advice and counsel, and complex litigation, wage and hour, all of the fun California employment things, and like I said, is based in Los Angeles, and she's based in Los Angeles along with Sam Rose, who is an associate in that office and also supports OSHA, workplace safety, and everything labor and employment related here in California. So you have almost the full team here for this presentation, and we're going to try to get through it as quick as possible because there is a lot of information happening. Cal OSHA continues to be very busy. I know that with the change of administration at the federal level, we anticipate some changes at Fed OSHA, but it's going to be most likely business as normal out here in California. And we actually anticipate that it will likely be even busier here in California if people remember the last Trump administration. Cal OSHA really kind of doubled down in some of the things that they were doing here in California. So we anticipate a similar reaction as we go into the second Trump administration. And with that, I'm going to turn it over to my colleague, Sam Rose, to kick it off on what we should expect in terms of a Cal OSHA staffing update.
Thanks, Rachel. So I'll kick off our enforcement update with a brief staffing update and then just a general overview of the current rulemaking that's being undertaken by Cal OSHA. So Cal OSHA has made hiring a huge priority recently. We've been talking for years now about how understaffed the agency is and how that understaffing has led to enforcement issues within the agency, but they've started to tackle that more seriously in recent months. So if you look on the slide, 18 months ago, their vacancy rate was 35%. And as of last month, it was down to 24%. And there's a few highlights here about where those positions have been filled. One important one is the Bureau of Investigations, or BOI. They're responsible for investigating and referring criminal matters that relate from Cal OSHA citations. And in that department, they filled at least 8 positions. And it's interesting because at one point they were all the way down to one investigator. There was hardly any movement going on in any cases that were placed on BOI hold. So that should start to clear out that backlog. We'll see if that has that effect. In addition, process safety management has doubled in size. So they are making big waves there, and consultation is now fully staffed. So for outreach or for employers to reach out to consultation, they should be able to access people over at the division now. So we see a big push in these areas, but we've also seen they've hired new COSHAs, they've hired new managers, and legal has also been staffed. They have a lot of new division counsel, which is helpful because cases get assigned to them, but it's also sometimes not helpful because the division counsels are new and don't necessarily know all the ins and outs of all the cases. So that's a staffing update. We'll turn to sort of the structure of Cal OSHA now. There's a new Region 8, which is managed by Regional Manager Eddie Miranda. That's a new region that they opened up, and they opened up a few field offices, which we'll show in the next slide. They also opened a new Agricultural Enforcement Task Force. This is similar to the Labor Enforcement Task Force. You might have heard of LEDIF, which is developed to combat the underground economy. But this one will be specifically focused on farm workers and ag employers. It's going to have 5 district offices and multiple field offices all across California. So definitely a sign that Cal OSHA and the division are very focused on agricultural workers, especially as Rachel pointed out, as we transfer to this new administration. We anticipate that this was going to be ramped up even more. So if we go to the next slide, you'll see a brief kind of like map of the new structure of Cal OSHA, where their regional offices are, where their district offices are, and then just pointing out the 2 new district offices in Santa Barbara and Riverside. So just a quick note on avian flu. Because of the rising level of it and the fact that certain industries have been heavily impacted recently, Cal OSHA obviously has put it on their radar. They're coordinating with CDPH and other agencies to monitor the virus across California. They've updated resources and have created a dedicated website to the avian flu. And then consultation has also started conducting outreach with employers, and employers are, of course, able to reach out to consultation if they have any questions on avian flu. So I'll just get us started on rulemaking with a broad overview, and then my colleagues will take over on specific ones that might be important to general industry. So there's in an advisory committee meeting in August and November, the division gave a lot of updates on where they're at with various rulemakings. There are over 20 rulemakings in the queue, but we'll just highlight a few of them right here. So first aid has been at the division for years. They're finally at a point where I think they're going to have it ready for rulemaking in early 2025. But interestingly, you might have heard that there's a new law that requires employers to have opioid reversal medications on site. And the division, the standards board, actually granted a petition that would require the same thing. But the first aid rulemaking is specifically not going to include the opioid reversal. They're going to address that in separate rulemaking. So first aid was already taking so long that I think they probably recognize that if they make it more complicated by adding additional medications or requirements, that will just put it off even further. So they're going to handle both, but opioid reversal is definitely going to be on the horizon. There's a couple bills out of the California legislature that require Cal OSHA to review and revise heat illness and wildfire smoke regulations. And so Cal OSHA is working on getting revised drafts of those posted, and we'll eventually schedule advisory committee meetings, but we haven't seen those yet. We've talked about this one before, but just a heads up for anybody who doesn't know, the Standards Board had recently granted a petition to remove petroleum, the word petroleum, from PSM and refineries regulations. So now it applies to all refineries, regardless of what type of fuel they're working with. Here we have silica and workplace violence. Megan is going to cover silica a little bit in more detail later on, and Rachel will be covering workplace violence shortly, so I won't get too far into those. But We also are anticipating new regulations on aerosol transmissible diseases, walking working surfaces, and a variety of other areas of Cal OSHA. So definitely keep your eyes out on our blog and our webinars for any updates that come out of Cal OSHA and the advisory committees related to these rulemakings. The last topic I'll cover is enterprise-wide and egregious violations. So SB 606 was signed into law back in 2021. Enterprise-wide and egregious violations are currently in the labor code, but Cal OSHA has not finished or really even begun their official rulemaking on the topic. So prior to opening formal rulemaking, Cal OSHA issued a discussion draft of amendments to Title 8 CCR 334 and 336. Those are the regulations that cover enterprise-wide and egregious violations. They've received comments on those on that draft, and we think that they're probably going to issue another discussion draft prior to opening formal rulemaking. So this is just the current status of their draft. Obviously, it will have a lot of changes between now and when it finally gets passed. But the main highlights are that an egregious violation is a willful violation plus an egregious in the last 5 years, or any one of 7 different categories. And you can see the 7 different categories here. 1 through 4, and then that's 5 through 7. I won't go into each one of them. We're going to issue the slides at the end of the webinar, so you'll be able to have them. But we also anticipate that these will be changing over time. So for enterprise-wide, there's a rebuttable presumption that a violation is enterprise-wide when either of the following are true. Either the employer has a written policy or procedure that violates a section of the health and safety code or the labor code, or the division finds evidence of a pattern or practice of the same violation or violations involving more than one of the employer's work sites. So 2 different ways that the division could ultimately decide to issue an enterprise-wide violation, and a pattern or practice of the same violation is probably the one that is the most concerning to employers, especially if they have multiple work sites throughout the state. If the division does find an enterprise-wide violation, then they can issue a citation up to $158,727. So pretty hefty penalties. You'll definitely want to make sure as this regulation goes through the rulemaking process and ultimately gets passed, that any of these types of violations are cured in each of your work sites, because they can add up fairly quickly. So with that, I will turn it over, or actually, I think we're going to cover COVID real quick because COVID never wants to go away. But the good news is it's close. The COVID rule is going to sunset in February 2025. The record keeping part will maintain until February 2026. But the heart of the regulation will be sunsetted in February. Cal OSHA, it's kind of interesting because we didn't really know how the division was going to bridge the gap between the COVID rule sunsetting and a potential ATD standard that incorporated COVID, or a general ATD standard that incorporated a variety of viruses. But at this point, it's pretty unlikely, given the timing, that a new regulation will be in place by the time COVID sunsets. So we anticipate there's going to be a gap between COVID sunsetting and any new potential regulation covering it. So with that, I will turn it over to Rachel to cover workplace violence.
Thanks, Sam. And a couple comments on enterprise-wide and egregious. Cal OSHA has basically said, the focus is probably going to be on the enterprise-wide classifications as opposed to egregious. As Sam noted, egregious is really kind of this willful plus. And Cal OSHA does not issue that many willfuls to begin with, only a handful each year. So they don't anticipate that they're going to get a lot of use out of the egregious classification. But the focus is really going to be on that enterprise-wide classification. So this is certainly a time for employers to take a look at, what what their policies and practices are, because if those are things that can be that are utilized throughout the state and throughout facilities, then that's something that you may want to, take stock of now to avoid any enterprise-wide potential classifications. And in terms of the COVID-19 update and this proposed permanent infectious disease standard for general industry, it'll certainly be interesting to see how it's written, if it's written closer to what we see for the ATD standard, for that's mostly utilized for healthcare facilities. If it's that kind of level of detail, it certainly won't be that detailed, or if it's something closer to what we saw for COVID. So stay tuned as we anticipate that draft coming out. So workplace violence, the Cal OSHA regulation. So I know most people here on this call had the pleasure of, putting together their workplace violence plan and training to be in compliance with the statute SB 553 that went into effect in July of this year. Well, of course, that doesn't mean that that's necessarily where this ends. According to the statute, the division now has to propose no later than December 2025 to the Standards Board a regulation, because again, we currently have a statute that Cal OSHA has been given authority to enforce, or to issue penalties and citations, but there is no Cal OSHA regulation. So they are now in the rulemaking process for that. And the regulation must have, essentially the statute becomes the floor, and Cal OSHA can include any additional requirements it deems necessary. And for those of you that have been following this for many, many years, there was several drafts of the Cal OSHA regulation prior to the statute. And that last draft was released in May of 2022. And at the end of the day, SB 553 ended up looking pretty similar to that regulation with some differences. But after lots of negotiations at the Capitol, it ended up looking pretty similar to what Cal OSHA had started to draft, but just could never get over the finish line. So Cal OSHA, SB 553 went into effect in July. Shortly after that, Cal OSHA released its draft regulation per the statute that it now is required to rulemaking on. And there was certainly a lot of revisions to it. And so we're going to go over some of the new revisions that are in it that you should be aware of. Of course, this is going to change through the rulemaking process, but just some things to be aware of, as I know many of you are in the process of implementing the workplace violence programs that you've recently rolled out. So the draft standard now includes examples of engineering controls and work practice controls. Some employers find that helpful. One of the concerns with that is all of the engineering, the engineering control examples and work practice control examples listed doesn't necessarily apply to every workplace. So does that mean that every employer has to consider these controls when they are evaluating their workplace and, make a determination as to why these controls may or may not be appropriate, or explain why they did not implement one of these controls? That's a potential issue with including these additional examples of these controls. It also inserted examples of workplace violence hazards. That's not too controversial. These are kind of pretty standard things that have been out there for a while. So I don't think that there's too much there to be controversial about. There's additional requirements for communicating with authorized employee representatives. It expands that further. It also, employer must create records and maintain records of workplace violence complaints, and keep the reporting employee's name confidential unless they expressly request that their identity be revealed. To me, that's a potential concern if you are investigating workplace violence complaints. If, there are times when you have to, in order to properly investigate, you have to reveal somebody's identity. Of course, that's not the first option, but there are times when that is necessary. Anybody who has participated in any type of employment-related investigation knows that best efforts are made to keep that person's name confidential, but that's not always possible when you're investigating a complaint. So I see certainly potential concerns there and limitations on how an employer can investigate because of that. Employers must also keep a record of corrective measures considered or implemented. So this one concerns me because you have to keep record of corrective measures you considered but didn't implement. So to me, that just means that that's going to be a basis for Cal OSHA to really push employers on and say, well, why didn't you, you considered this and you didn't implement it, why not? And really second guess an employer as to why they didn't implement those corrective measures. So I certainly see, some friction there between employers and Cal OSHA when we're getting kind of the Monday morning quarterbacking from Cal OSHA on why something wasn't implemented. Employees can remove themselves from any unsafe condition. I don't think that's too controversial. There's also some additions to when inspections need to be conducted. This aligns a little bit more with the IIPP. And the next one, a new prohibition on confrontation policies. This was something that was in one of the Cal OSHA drafts originally. Something similar kind of bopped around in the statute. This is one that I know certain industries really have a tough time with. And essentially, it says that employers cannot require or encourage employees to confront persons suspected of committing a criminal act or persons suspected of engaging in workplace violence, with the exception being dedicated security personnel. So one of the issues here is, what does confronted mean? I don't think anybody has a policy where they require, their non-security folks to go and, stop a robbery. But does that mean that somebody can't, speak to a person? What does confronting mean? This was something that was negotiated heavily during the legislative process, and it was removed as part of that. And so now Cal OSHA put that back in. So I know some industries are really frustrated with Cal OSHA because this was something that was already agreed to remove, and Cal OSHA included it back in. So we'll see how that ends up shaking out. Some additional requirements for new post-incident procedures. If you currently, you're required to have post-incident procedures, but it doesn't really get into what is required to be in there. And this is more prescriptive in terms of what's required. One of the things in here I want to just flag is soliciting employees involved in the incident for their opinions regarding the cause and whether any measure would have prevented the incident. I understand why you put that in there. Employees are on the front lines, or if they're the victims of it, you want to get as much information from them as well. However, employees aren't workplace violence experts. And so sometimes I see this all the time in traditional Cal OSHA inspections is they love to ask employees, well, what would have prevented the accident? And then I see employees kind of speculate as to what may have prevented it, but they may not be an electrical expert or workplace violence expert. And then Cal OSHA tends to take that and use that as the basis for the violation. So, this is one where, again, I see some friction between Cal OSHA and employers, because in theory, yes, we want employees' input. They're on the front lines of this, but again, they're not always experts in workplace violence and may not be qualified to give an opinion on what caused the incident. And if Cal OSHA is going to take that opinion and issue a citation around it, I think that can be pretty problematic. In addition, there are some more information about procedures related to the post-incident. One of the things is for employers with 25 or more employees, making available individual trauma counseling for employees affected by the incident. If you recall, workplace violence is incredibly broad as defined. So, one of the potential concerns here is, if there is kind of a minor workplace violence incident, now we have to bring in trauma counseling. And what does trauma counseling mean? Is that just providing EAP, or is that something else? And then here's just kind of a timeline. We anticipate that this is probably not going to see go into effect until 2027, but Cal OSHA doesn't always stay on track in terms of deadlines. So we'll wait and see as to when we actually get a new or a regulation promulgated. And just quickly, current workplace violence, Cal OSHA enforcement. Andrea and I have been working on some workplace violence cases right now, and they're pre-July 2024, so they don't involve the actual statute. But part of the abatement, of course, is whether or not the workplace violence program is compliant. And working with Cal OSHA, kind of the ways that they have indicated to us that they review these plans and programs is they once review your plan for all of the elements. Then they review it again to ensure that it has enough detail. And then if it's related to a incident, they review the plan again to see if it addresses the potential hazard. And for multi-employer sites, they may compare employer plans to each other to see if they actually are have coordination. And of course, we don't anticipate Cal OSHA is going to have consistent enforcement around this. Inspectors, DMs may all take different approaches until kind of this really gets going. So California legislative updates. Sam kind of talked about, there's kind of these dual situations happening where we have the California legislature pass some statutes. We also at the same time have Cal OSHA petitions that have been granted. And so these will kind of have to be worked out as both exist and require the standards board to do similar things, although potentially a little bit different. So the first one is was enacted is including in first aid kits or having Cal OSHA submit a proposal to the standards board to require in first aid materials naloxone, which is an opioid reversal medication. Now, Sam talked about the petition that's out there, and one of the differences is that the statute requires us to go into first aid, and the petition requires it to be on site. Anybody who has been part of attending standards boards meetings for many years knows that first aid is has been kind of a long drawn out process to revise. So adding on this new requirement kind of throws a wrench into what's already been a complicated revision process. And so, one of the things that, I think in theory, Narcan, which is one of the brands of the medication for opioid reversal, having this on, site, I think, most people think that it doesn't cost a lot. There's no negative effects of treating an employee or anybody on your site with it, even if they're not experiencing a overdose. However, Cal OSHA released a hazard alert letter around opioid reversal medication earlier this year, and they listed out all the things that they would recommend employers to have in programs and in training. So, I think that, again, in theory, having this on site is, makes sense to a lot of people. However, you're now going to have to also include potentially, depending on how Cal OSHA writes the regulation, and of course, even if they don't include these types of things in the regulation, it's a potential IIPP violation if you are not, identifying hazards and training employees correctly. So, employees administering this medication does potentially introduce additional hazards to those employees. And I won't go through all of these. You can take a look at it on the slides. But, one of the things to kind of think about is, for example, bloodborne pathogens. Employees may be exposed to bloodborne pathogens if they're administering this medication. So things like that. So, it requiring this medication to be on site does not sit in a silo, and it does invite some potential additional hazards to employees that now employers are going to be required to consider and to mitigate and to train on in their workplaces. So it is potentially a bigger undertaking than just having the medication on site. And a lot of employers have, concerns about this type of regulation or including this in the worksite because overdoses from opioids is not an occupational hazard. Employers don't require employees to take opioids as part of their job duties. So we're talking about a hazard that comes into the workplace and is not a work-related hazard, but employers are now going to be required to be involved in. And then just lastly, new weapon detection policy for hospitals. And this will require the Standards Board to amend the workplace violence and healthcare regulation to include weapons detection policies and trainings. This was, controversial when that regulation originally came out. It kind of got neutralized since then. A lot of ERs that you go to now actually do have some type of weapon detection policies. I was actually at an ER on Monday and had to go through a metal detector to go in. So I don't think this one is quite as controversial as it was when the statute or the regulation was originally implemented and was considered. Also, this is also one 3258 refineries requiring the removal of petroleum from the PSM regulation that deals with that to expand the coverage of that regulation. There's also the petition at the Standards Board, so that's another one that's kind of being changed from two angles. And with that, that's kind of an overview of some of the new regulations. And now I'm going to hand it over to Andrea to review some of, that's some of the regulations that we're looking at coming down the pike. And now Andrea is going to kick us off on some of the new regulations that were passed in 2024 that are still in the process of being implemented.
Okay, thanks, Rachel. So as Rachel mentioned, I'm going to kick you off with going over the new regulations that Cal OSHA passed in this last year. So Cal OSHA has been focused on heat illness prevention for quite a while now. And as most of you know, Cal OSHA passed its outdoor heat illness regulation back in 2005. And then in 2016, Governor Brown directed Cal OSHA to create a rule to protect employees from indoor heat illness. And that standard was supposed to be completed in 2019. Obviously, that didn't happen. There were multiple iterations of the rule before it was finally approved by the board in March 2024. It was then, there was a little drama around it. It was then disapproved by the Office of Administrative Law and sent back to the board to have it revised to exempt some public sector employers, which the board did, and then approved it again, and it finally went into effect July 2024. Okay, so the new rule applies to all indoor work areas where the temperature equals or exceeds 82 degrees Fahrenheit when employers are present. And the standard does not apply to prisons, detention facilities, juvenile facilities, places of employment where employers are working or teleworking and that are not under control of the employer. Emergency operations, and then it is also does not apply to incidental heat exposure, where employees are exposed to temperatures at or above 82 degrees and below 95 degrees for 15 minutes or less in any 60-minute period. So when you hit that threshold of 82 degrees, there's various things you need to do. So you need to develop a written indoor heat illness prevention plan. And this could be either a standalone plan or combined with your IIPP. We always suggest that it be standalone. Just so if OSHA comes knocking, you can just provide that if they ask for that specifically, and not provide them more policies than you need to. So the indoor heat illness plan needs to include at minimum what's listed here. So it's procedures, for example, for providing water, for providing cool down areas, rest breaks, procedures to measure the temperature and heat index and record whichever is greater, to identify and evaluate environmental risk hazards, implement control measures, procedures for emergency response and acclimatization, and so yeah, so you have that heat illness plan. Again, one of the procedures you need to have are regarding drinking water. So employees must be provided water that is fresh, suitably cool, and free of charge. And the water needs to be located as close as possible to the work areas and in the cool down area. If the water is not continuously supplied, you need to provide at least 1 quart of water per employee per hour. And if you cannot provide this much water at the beginning of the shift, then you need to have written procedures to show that how you're going to replenish that drinking water. And the procedures need to be more than just waiting for an employee to complain about not having enough drinking water. And then employees also need to be reminded and encouraged to drink frequently throughout the day. Okay, so you must also provide employees with cool down areas. So that's indoor or outdoor areas that are blocked from the sun or other high radiant heat sources. They can either be open to the air or have ventilation and cooling if they're not open to the air. And they must be maintained at least below 82 degrees unless you can show that it's infeasible to do so. And they must be located as close as possible to the employees' work areas and large enough so employees can see comfortably with everyone else that's on break without touching each other. Again, employees must be encouraged to take cool down rest breaks in the cool down area, and the cool down breaks cannot be less than 5 minutes. And just note that that does not include the time where it takes to get to that cool down area. And then anyone taking a cool down break needs to be monitored. They should be asked about their symptoms. If they're experiencing any symptoms, they cannot go back to work until those symptoms have subsided. And if needed, they need to be provided the appropriate, first aid, and you need to implement the emergency response procedures as needed. So there's also an acclimatization requirement. So basically a supervisor or some designated worker needs to closely observe workers for the first 14 days if they have been newly assigned to a work area where the temperature reaches 87 degrees Fahrenheit or 82 degrees Fahrenheit if they're wearing restrictive clothing or working in a high radiant heat area. And they also need to be closely observed during a heat wave. Okay, so additional requirements kick in when the temperature equals or exceeds 87 degrees Fahrenheit or the 82 degrees Fahrenheit, again, if the employees are wearing clothes that restricts heat or working in a high radiant heat area. So your first measurement should be taken when it is reasonable to suspect that the temperature is going to hit these higher thresholds. And then measurement should be taken again when you believe it'll be 10 degrees more than the previous measurement, and at times during which employees are going to be exposed to the highest temperature heat index. So you have to take those measurements and then record whichever is greater. So you have to take the temperature and heat index and then record whichever is greater. The record should have date, time, and specific location of all measurements, and they need to be retained for 12 months or until the next measurements are taken, whichever is later. You also need to conduct an evaluation of the environmental risk hazards for heat illness, and you need the active involvement of employees and their union representatives when measuring the temperatures and conducting the analysis. So in lieu of doing all these assessment requirements, you can also just assume that your work area meets the criteria for implementing the control measures. So essentially there, the employer can choose to start implementing control measures at 82 degrees and forgo everything all the assessment requirements I just spoke to. Okay, so when these upper levels are hit, employers need to start implementing control measures to try to reduce the temperature and heat index to below, again, the 87 degrees or the 82 degrees if you're wearing restrictive clothing, unless it is unfeasible to do so. So employers start with implementing engineering controls. If those aren't sufficient, they can move on to administrative controls and then personal heat protective equipment. And then finally, employers must implement effective emergency response procedures. And if you have an outdoor plan, you're pretty much familiar with these requirements. There's an emphasis on communication. If you also have effective procedures regarding detecting and responding to heat illness symptoms, and then also contacting emergency services, including like providing directions on how to get to that sick employee. And then finally, you need to train your employees, and the requirements are quite substantive. I have a list here. I'm not going to go over everything, but just note that all employees need to be trained on everything here. And then the supervisors must also be trained. If your work area is affected by the outdoor heat, they must be trained on how to monitor weather reports and how to respond. Okay, and then just really quickly, I attended a webinar by OSHA on the new standard, and I just wanted to go over some takeaways. There is no grace period, and as we see now, OSHA is moving forward with citing employees on the new standard. So basically, if you don't have a plan in place, it's really time to start thinking about getting that implemented. The next takeaway is that if you're going to use an infeasibility defense, make sure that you've conducted an assessment, and determining infeasibility is very fact specific. So look at like your work size, your environment, what type of work is being performed. You're not required to have documentation of a feasibility assessment, but we think it's a really good idea to have documentation. In case you get cited for this, you want to be able to prove that these measures were in fact infeasible. And another thing to remember is just that the multi-employer worksite rules are still in play. So make sure you're taking the appropriate steps to protect your workers and any other workers at your worksite. And finally, it's become clear that even if your worksite has air conditioning, OSHA still expects you to have a plan in place in case the air conditioning malfunctions. And so, even if you say, well, the air conditioning malfunctioned and you want to prove, you're saying that, you haven't hit that 82 degree threshold, OSHA wants evidence of that. And we've seen that through inspections. So it's a good idea to start taking temperature measurements and have records of those measurements. if your air conditioning malfunctions, and if there's any chance that you're going to hit that 82-degree threshold. Okay, and now I'm going to pass it along to my colleague Megan to go over the other new regulations.
Thanks, Andrea. So I'll take just a few minutes. I know we're getting closer to the top of the hour, but did, in case you missed it, want to provide an update on a few more regulations that have passed or in the works. So the first one is lead, and this one is a significant change to the lead standard, and the changes are made in both the regulation that applies to general industry as well as the regulation that applies to the construction industry. And you'll see in the next couple of slides that it's a significant expansion of the applicability of the regulation, sweeps in employers who were not previously covered, and really drastically reduces the kind of trigger points, the points at which employers are obligated to take steps to be in compliance with the regulation. There was a delayed effect of these changes. So even though it was passed and approved a while back, their expected date is January 1st, 2025. I will say that in recent updates that Cal OSHA has provided through both the advisory committee process, the advisory meeting process, which happens a few times a year, as well as the regular standards board meetings, which our California team attends so that we're up to date on this stuff. There were requests from the public for a delayed enforcement period, partially in response to the fact that this is a really huge change, and also a response to updates from the division that they're putting out guidance materials, including model plans, frequently asked questions, and fact sheets. So there was naturally a request that if this information is just now being provided to employers, would there be a willingness to have a delayed enforcement? We will see what comes of that. But in the next slide, I can give some additional overview. So you understand kind of what these revisions do. And this, if you look at the revisions together, it's very, very long. So if this is something that applies to your industry, or you think might apply to your industry, it's definitely worth a close look and consultation with OSHA counsel to make sure that you're understanding the obligations. So like I said, it does lower the threshold that activates various employer requirements, and the things that are impacted are things like the written compliance program, the exposure monitoring, medical surveillance. These are based on the kind of trigger thresholds that you have to pay attention to are the permissible exposure levels and then the action levels. These are all tied to the airborne concentration of lead over an 8-hour time-weighted average. And there are some additional expansions that require employers to take into consideration not only the impact of lead, but the additive effect of lead with other exposures to chemicals that are, naturally occurring in the same sorts of environments, like mercury and arsenic and other such chemicals or minerals. So, okay, so this shows the reduction in the exposure limit. So under the old version of the standard, you had an exposure limit of 50 micrograms per cubic meter of air. The exposure limit has been reduced from 50 to 10. So there are some exceptions for certain industries and activities that are known to have high exposure levels already. The other action level that has changed is, the other trigger that has changed is the action level, which was originally 30 micrograms per cubic meter of air, regardless of use of respirators. That has now been reduced to 2. So you can see really, really huge change to these regulations. So that's lead. Again, if you're impacted by lead, feel free to reach out if you have any additional questions. And then same thing with silica, which we know it impacts only certain industries, but did want to give a brief update since this has been in the works. This, for those of you who haven't been tracking this rulemaking stems from concerns that CDPH and Cal OSHA was seeing increased cases of silicosis, particularly related to work around engineered stone, cabinetry, and things like that, as well as concerns coming out of an audit based on compliance with the current silica standard, where they were seeing a lack of compliance with that existing regulation. So we had an emergency temporary standard to deal with the most pressing concern about the rise of silicosis amongst workers working around engineered stone. And then at the same time, or shortly thereafter, the division worked on a rulemaking to incorporate some of the additional requirements and expansion that was in the emergency temporary standard to get that into the silica standard. So the ETS will be replaced by the revised permanent regulation that is currently in the second 15-day comment period, recently closed. And the next slide gives some of the details of that. Actually, the slide after that gives some more details about the change in the second 15-day notice if you're impacted by this. But generally speaking, the changes that they're looking for are expansions to the written exposure control plan requirements, the precautions that employees have to take if there is potential exposure, training, expansion of requirements for respiratory protection, as well as monitoring and reporting. So these are, again, the division is working through the formal rulemaking process, getting comments on the draft, and then issuing new versions. So we're currently on the second 15-day notice is the one that is expected to be presented to the board for potential vote. Just a couple more reminders in case folks missed it. We had an adoption of a change to the fall protection regulation for residential construction for quite some time. We have had a distinction in the Cal OSHA regulation for fall protection that was a higher threshold than the federal requirement. Federal OSHA came in and pushed very hard for alignment with the federal standard, despite the fact that industry, the regulated community, Cal OSHA labor folks were in alignment and confident with the safety and the effectiveness of the Cal OSHA regulation. Fed OSHA essentially put their foot down and said, no, there needs to be alignment. And so the Standards Board did ultimately approve that change during the August meeting. And so that will go into effect. And then the final one we have for you is on the e-record keeping requirement. This one stems from an expansion at the federal level of the requirements for employers to report occupational injuries and illness data. And because, as we mentioned from time to time, Cal OSHA is required to be at least as effective as the federal standards. There was a process for Cal OSHA to make corollary amendments to its record keeping requirements so that those are aligned. And that change went into effect October 24th, 2024. So that's now wrapped up at the California level. And this is a reminder for folks on what that federal expansion was, so that you can track those expanded e-record keeping obligations. But again, feel free to reach out if you have any questions on the record keeping requirements in general or the e-record keeping requirements specifically. And with the next slide, I think we have reached the end of our content slides. We wanted to, again, put you in a position to know what needs to be done now, what might be coming down in the future for 2025. So you're all prepared for the new year. We keep our Cal OSHA Defense Report and our additional blogs up to date with really significant changes, but you can always reach out to us if you have questions on anything, or you have a request for a topic for us to cover either in the blog or a future webinar. We are working on our slate of monthly webinars for next year for all of our webinar series, our OSHA webinar series, our Cal OSHA webinar series, our labor and employment. And so keep your eye out for those. If you're not already subscribed or receiving those emails, we're happy to keep you in the loop so you know when those are coming. We can take a look in our next few minutes to see questions. I know there was also a question about the COVID record keeping requirement, since the COVID non-emergency rule sunsets at the end of February 2025, but the record keeping hangs on for another year. The regulation is specific about what record keeping requirements continue for that additional year. It's generally speaking, if you're keeping records of COVID cases and you're keeping folks' information, that information needs to be retained for an additional period of time. Likewise, if you're keeping information of tracking a COVID case to see if anybody else may have had close contacts, particularly in an outbreak or a major outbreak, there may be additional records that you'd want to hang on to for a little while longer. So happy to answer additional questions or specifics about how to handle that, best practices, and what we would expect, how we would expect that to play out practically. Thank you so much for joining. And if we missed any questions, again, we're happy to talk more offline.